Hello and welcome. I am Dr. Manvendra Kumar Tiwari and I am an associate professor at the Dharmshastra National Law University, Jabalpur. Today, continuing our discussion forward in respect of legal reasoning, we will discuss some recent developments in constitutional law, and I have labeled it as Recent Developments 1. In this reference, we will discuss a judgment delivered by a 9-judge bench of the Supreme Court of India in the Property Owners Association versus State of Maharashtra. The judgment has been delivered recently in the last week of the tenure of the earlier Chief Justice of India, Dr. D.Y. Chandrachud. And Dr. D.Y. Chandrachud also was the one who wrote the majority opinion in this case on behalf of 6 other judges. On 5th November 2024, a 9-judge constitution bench in Property Owners Association versus State of Maharashtra held that not all privately owned property could form part of the material resources of the community under Article 39B of the Constitution in an 8:1 majority judgment. Now, Article 39B of the Constitution of India is a directive principle of state policy, and we have seen in our earlier discussions that the Parliament of India, by the 25th Constitutional Amendment, had brought a new provision into the Constitution of India in the form of Article 31 capital C. And Article 31 capital C gave overriding effect to the legislations that have been enacted following the principles underlying Article 39B and C over Article 14 and 19. So Article 31C prevents a challenge in a court of law to the constitutionality of legislations that have been enacted following the principles underlying Article 39B and 39C of the Constitution of India. Article 39B says that the material resources of the community should be so distributed so as to subserve the common good. And therefore, in this case, the question was whether material resources includes all privately owned properties, because that is the bone of contention. What do we mean by material resources? Whether privately owned property is a material resource. Now, the court in this case said not all. That means some private property is definitely material resources, in the sense that private property is not excluded from the purview of material resources, which can be distributed in such a manner so as to subserve the common good by way of a legislation. But the question is whether all privately owned property can actually be the subject matter of a legislation where the objective is to actually ensure even distribution of property. And the court, as it is visible, said that private property per se is not excluded from material resources, but that should not also be taken to mean that all private property is therefore a material resource under Article 39B. So the court gave something, but at the same time, the court also restricted something. As opposed to this, the minority opinion of Justice Sudhanshu Dhulia, he was of this view that all privately owned property could actually form part of the material resources of the community, and by a legislation, all private property can also be so distributed so as to subserve the common good. Now, the bench led by the Chief Justice D.Y. Chandrachud also unanimously held that Article 31C continues to exist in the Constitution after the court's decision in Minerva Mills. And that's a unanimous verdict. Now, what is this second paragraph talking about? Now, the 25th Constitutional Amendment, which inserted Article 31C into the Constitution of India, gave primacy to legislations enacted with a view to further the objectives underlying Article 39B and 39C of the Constitution of India, but the 42nd Constitutional Amendment substituted the expression the principles of 39B and C with all or any of the principles forming part of Part 4 of the Constitution. That means 42nd Constitutional Amendment gave primacy to all the legislations which may be enacted furthering the directive principles of state policy. And it prevented a judicial challenge in a court of law on the ground that the law violates Article 14 and 19. However, in Minerva Mills versus Union of India, the Supreme Court had declared this 42nd Constitutional Amendment, which so amended Article 31C, to be unconstitutional. And therefore, the question was whether after Minerva Mills, which declared the amendment in Article 31C unconstitutional, whether the provisions of Article 31C as upheld by the Supreme Court in Keshwanand Bharati, whether it still existed, or is it the case that after Minerva Mills, the entire 31C has ceased to exist? And the Supreme Court in this case unanimously answered that 31C, as it was upheld in Keshwanand Bharati, continued to exist even after the declaration of unconstitutionality of the provisions of Article 31C, which were inserted into the Constitution by the 42nd Constitutional Amendment. Now, Article 39B, a directive principles of state policy, obligates the state to ensure that the distribution of material resources of the community be so distributed so as to subserve the common good. In state of Karnataka versus Sri Ranganatha Reddy in 1977, 5 judges of the Supreme Court debated whether privately owned resources fell under the ambit of material resources of the community. A minority opinion by Justice Krishna Iyer stated that the private property fell in the ambit of Article 39B. That means the majority opinion was not of the view that the privately owned property also forms part of the material resources of the community for the purposes of Article 39B. 5 years later, a 5-judge bench in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited, led by Justice Chinappa Reddy, adopted Justice Iyer's minority view. And in 1997, a 9-judge bench in Mafatlal Industries Limited followed the Sanjeev Coke precedent. The challenges of the present case arose in 1986, this present case coming from Maharashtra, when the Maharashtra government amended the Maharashtra Housing and Area Development Act 1976 to insert Chapter 8A and Section 1A. Chapter 8A allowed the Mumbai Building Repair and Construction Board to acquire certain cessed properties, primarily old dilapidated buildings in Mumbai, for restoration purposes with the consent of 70% of the residents. Section 1A declared that the act was aimed at implementing the principles enshrined in Article 39B. In December 1991, the Bombay High Court dismissed the petitions challenging Chapter 8A. The court reasoned that the government was only trying to protect the shelter of the occupiers in old dilapidated buildings and saving life and property by preventing collapse of such buildings. Further, the High Court also held that Article 31C of the Constitution bars any challenge on the grounds of Article 14 or 19 if the statute has been enacted in furtherance of Article 39B. The petitioners moved the Supreme Court. Introduced through the 25th Constitutional Amendment, this is about Article 31C in 1971. Article 31C did 2 things. For the first part of Article 31C declared that the laws advancing the principles of state policy in 39B and C cannot be declared void for being inconsistent with Article 14 and 19, as we already saw. The second part, there is a second part to Article 31C as inserted by the 25th Constitutional Amendment, which said it saved such laws from being challenged in a court of law if they fail to give effect to the principles enshrined under Article 2 DPSP. So that means the legislation may claim that it is doing so, but sometimes the legislation may not actually give effect to the principles of 39B and C. Article 31C prevented a challenge by this argument also, that the law, though declares that it is giving effect to the principles of 39B and C, but in a sense it is not doing so. This argument was also prevented to be brought before a court of law by this Article 31C. In Keshwan Bharati versus State of Kerala, a 13-judge bench, constitution bench, struck down the second part of the provision. The provision that we just read out. Keshwan Bharati is famously known for developing the basic structure doctrine of the Constitution. After the decision in 1976, Parliament passed the 42nd Amendment. Section 4 of this Act substituted the words Clause B or Clause C of Article 39 in Article 31C with the words all or any of the principles laid down in Part 4. This is via 42nd Constitutional Amendment. In a sense, it extended the scope of 31C to encompass all DPSPs. Later in Minerva Mills, Minerva Mills versus Union of India, 1980, a 5-judge bench, constitution bench, struck down the substitution as unconstitutional. In property owners, the question emerged: did the narrower version of Article 31C, as it was upheld in Keshwan Bharati, survive, or was the provision effaced in its entirety? Property owners challenging Chapter 8A of the MADA contended that after Minerva Mills, no version of Article 31C existed in the Constitution. The respondents relied on the doctrine of revival to claim that after the substituted text of the provision was struck down, its narrow version, as upheld in the court in Keshwan Bharati, was restored. Does Article 31 remain in the Constitution? All 9 judges agreed unanimously that Article 31C remains in the Constitution post Minerva Mills. It is not appropriate to separate an amendment which substitutes certain words with certain other words into multiple steps and examine the legal effect of invalidation on each of these steps independently, CJI Chandrachud wrote. He explained that when an amendment involves the substitution of the original text of a law with a new text, the two acts, removing the text and inserting an alternative text, happen simultaneously. Therefore, assessing the validity of each step separately would be contrary to the legislative intent. In this case, he said, legislative intent has two expressions, the original and the revised text. Invalidating the amended text leaves the original as the sole legitimate expression of the legislative intent unless there has been repeal of the original. The Chief Justice elaborated that in instances where a substituted text of a law is invalidated, as has happened in this case, a substituted text of law, the question that needed to be answered was, would the legislature have repealed the original text without giving effect to the amended text? Unless the legislature expressed its clear intent to repeal the original text, it is presumed that the unamended text stands revived. But if the court were to invalidate the original text as well without its express repeal, it would result in a third outcome, a legal vacuum, which was neither intended by the legislature that enacted the original text nor by the legislature which adopted the amended text. Crucially, the chief noted, this third outcome would fail to give effect to either legislative intent despite there being no constitutional fault in the original provision. Now, these are from a judgment summary by R. Sai Spandana in Supreme Court Observer, published on 7th November 2014. So applying these rules to Article 31C of the 31C, the Chief Justice held that the invalidation of the substituted text of the 42nd Amendment meant that the original text, to the extent it was upheld in Keshwan Bharati, was revived. Because what was declared unconstitutional was that portion that was inserted after the 42nd Amendment into Article 31C. So the original version of Article 31C, as inserted after 25th Amendment, which was declared constitutional by the Supreme Court in Keshwanan Bharati, that stands revived after the 42nd Amendment's substitution in 31C was declared unconstitutional by the Supreme Court in Minerva Mills. If Parliament had the intent to remove the original text, it would have done so in an expressed act of repeal. After Minerva Mills invalidated Section 4 of the 42nd Amendment, the composite legal effect of Section 4 was nullified and unamended text of Article 31C stands revived. And Justice Nagaratna and Dhulia, who wrote concurring opinions, they also concurred with Chief Justice on this reasoning. Udhulia has also written his dissent, but on this question, both have concurred with the Chief Justice. So it's a 9 judges bench, unanimous view, therefore. Now we'll see a few questions. The bench led by the Chief Justice D.Y. Chandrachud unanimously held that Article 31C continues to exist in the Constitution after the court's decision in Minerva Mills versus Union of India. Minerva Mills declared the 42nd Amendment substitution unconstitutional, but as it was declared constitutional in the earlier version in Keshwanan Bharati, so that remains. So the court, after the Minerva Mills, the Keshwanan Bharati's version and the 25th Constitutional Amendment version is revived. The minority opinion by Justice Krishna Iyer stated that private property fell in the ambit of 39B instead of Karnataka versus Ranganatha Reddy D. A 5-judge bench in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited, led by Justice Chinnappa Reddy, adopted the minority view of Justice Krishna Iyer. The judgment of Sanjeev Coke was followed by the 9-judge bench in option A, Mafatlal Industries Limited versus Union of India. The Maharashtra Area and Housing Development Act 1976 declared that the act was implementing the principles of option B, 39B. The Bombay High Court held that if an act has been enacted in furtherance of the principles of Article 31C, Article 31C of the Constitution bars any challenges to the enactment on the grounds of violation of 14 and 19. That's what 31C says. So option C is the right answer. The second part of Article 31C, as inserted by the 25th Constitutional Amendment, which saved laws from being challenged in the court if they failed to give effect to the principles enshrined under Article 39B and C. Yes, option A is the right answer, and this part was declared unconstitutional in Keshwanan Bharati itself, the second part of Article 31C. Parliament passed the 42nd Amendment Act, Constitutional Amendment. Section 4 of this Act substituted the words Clause B or Clause C of Article 39 in Article 31C with the words all or any of the principles laid down in Part 4, that is DPSP. So option A is the right answer. In Minerva Mills versus Union of India 1980, a 5-judge bench declared the amendment made in Article 31C by the 42nd Constitutional Amendment to be unconstitutional. That's why the entire controversy as to whether 31C survived, any version of 31C survived or not after the declaration of unconstitutionality in Minerva Mills. And finally, the Chief Justice held that the invalidation of the substituted text of 42nd Amendment meant that the original text, to the extent that it was upheld in Keshwanan Bharati, is revived. So option A again is the right answer. Thank you very much.